This is the 13th and final lecture in our course, Principles of Company Law. Today we'll be looking at the presence of foreign companies in Hong Kong courts. So our analysis will be primarily jurisdictional. We'll look at the notion of the non-Hong Kong company, which is essentially a foreign company subject to the jurisdiction of Hong Kong courts. Then we will look at the application of Part 14. You'll remember that Part 14 is the investor protection section of the company's ordinance. It includes the unfair prejudice action, the injunctive action, the derivative action, as well as the possibility for a shareholder to request information from the company if that shareholder acts in good faith and for a proper purpose. And then we'll look at a new topic, which will allow you to start thinking somewhat about what comes beyond this course, which is the winding up of a company in Hong Kong. And in this case, what jurisdictional elements must be present in order for the Hong Kong court to take jurisdiction over the winding up of a foreign company. So let's look at non-Hong Kong companies first. One of the reasons why we really must focus on non-Hong Kong companies is the Stock Exchange of Hong Kong, which has about 2,000 listed companies, is primarily foreign. Currently, at the end of 2017, we have only 13.5% of the listed companies being incorporated in Hong Kong, with an entire 41% incorporated in the Cayman Islands and another 31% in Bermuda. So that means that the companies that are operating and selling shares to investors through the Stock Exchange of Hong Kong are not subject to Hong Kong company law. And the investor protection section of Part 14 reaches out to bring these companies into court to protect investors. We have the possibility of registering a foreign company as a non-Hong Kong company under Part 16 of the company's ordinance, and the registration is not burdensome. Essentially, when a company is registered, it will de jure create a place of business in Hong Kong. The constitutional documents must be made available to the company's registry, which will then make them available to the public. Particulars of the directors must be disclosed. An authorized representative for the service of process were the company to breach a contract or enter into a tort in Hong Kong is necessary, as well as annual return information, updating what we have discussed in the first few bullet points. And then if annual accounts are submitted abroad, then annual accounts must also be submitted in Hong Kong, essentially equal receipt and equal availability of information in Hong Kong for what a foreign investor would have present in, say, the Cayman Islands or Bermuda. And then if liquidation proceedings commence, that must be notified to the company's registry. So this is the non-Hong Kong company by declaration and registration under Part 16 of the Hong Kong Companies Ordinance. When we apply Part 14 of the ordinance, we're looking primarily for a place of business. That's because the company, as defined in Part 14, includes a non-Hong Kong company, and a non-Hong Kong company is a company with a place of business in Hong Kong. Now, why we think about this is that companies tend to carry their own law with them into a foreign jurisdiction. A company will be governed by the laws which have created it. In this course, you've learned how to set up a company under Hong Kong law. You've learned the rules for financing that company, as well as the rules for governing the company. And if a company were established in the Cayman Islands, then the establishment of the company, the governance of the company, and the financing of the company would proceed under Cayman Island law. This is referred to as the incorporation theory, that a company will bring its law with it wherever it goes in the world. That, of course, does not include law triggered by dealing with third parties, such as contract or tort law or criminal law, for that matter. So when we create the possibility to bring a non-Hong Kong company into a Hong Kong court, we're essentially reaching out from Hong Kong and controlling, to a certain extent, the internal operation of a foreign company by applying rules on, say, directors' duties, for example, to the behavior of directors of that foreign company, which is an internal matter, but Hong Kong regulates it because of the way the company is defined in Part 14. So, as I said, this contains the investor protection sections of the law. Company, under Part 14, Section 722, includes non-Hong Kong company. A non-Hong Kong company, under the definitional Section 2, is a company with a place of business in Hong Kong. If we look to Section 774, we'll see that a company with a share transfer office is a company that has a place of business in Hong Kong. And then if we look to the rules of the Stock Exchange of Hong Kong, we see that every listed company must have a share transfer office in Hong Kong, which essentially makes all listed companies non-Hong Kong companies for purpose of applying Part 14. When a company is not registered under Part 16, then we have the problem that arises in Yunkai Holdings, where we try to establish whether the company has a place of business in Hong Kong. So you'll remember that Yunkai Holdings is a British Virgin Islands company, and Yunkai has a subsidiary which is the active holding company of the Yunkai Group. So Yunkai Holdings actually has only one asset and one function, and that is to hold shares in Long Yao. Long Yao holds shares in a number of companies, both in the British Virgin Islands and in Hong Kong. The primary, or the beginning of this group, is the Yunkai restaurant on Wellington in Central. So we have the dispute between Quan Sing and Quan Lai, and in order to examine this unfair prejudice dispute, the court must first understand whether the unfair prejudice provisions apply, that is, whether Part 14 applies, and so that is whether the Yunkai Holdings has a place of business in Hong Kong, because Yunkai Holdings is not registered under Part 16. So here I'm just giving you some of the analysis taken from the Court of First Instance decision. And the court points out, as all decisions on this topic point out, that there's a distinction between carrying on business and establishing a place of business. You'll remember that Hong Kong has a large convention center, and what you may not be aware of, because perhaps you visit the convention center for cultural events. However, a convention center is set up to a great extent in order to hold trade fairs. And trade fairs are a place where one makes contracts. People from all over the world will come to meet other people from all over the world, present their products, and they may sign a contract on the floor of the convention center. And if Hong Kong were to take jurisdiction of every company that sold a product or bought a product in the Hong Kong Convention Center, this would be something which would certainly frighten the participants of those transactions when considering to do their business in Hong Kong. And so doing business is not the same as establishing a place of business. So a place of business does not have to have any particular form. It need not be specific discrete premises. It need not be an office or a factory where the company permanently establishes, owns, or leases. However, there must be some degree of permanence and regularity. And there you go to the distinction between a place of business and doing business. We've got an important aspect which looks a bit like estoppel. So if the public recognizes a particular company as having a place of business in Hong Kong, and this can also include declarations to the public that we are in Hong Kong permanently to stay. You can rely on that. If at that point a company creates public trust in its permanent presence, and then 6 months later in court denies that it ever had a permanent presence in Hong Kong, then there would be something of an estoppel nature to this, and that is therefore an important aspect of the analysis of the place of business, that there would be declarations and recognizability to the public. This also goes to declarations to authorities. If a particular entity were to declare itself in some way to the Securities and Futures Commission, or the Hong Kong Monetary Authority, or another licensing authority, this, and providing an address in Hong Kong, this would be a strong evidence that the company has the permanence and regularity and recognizability to establish a place of business in Hong Kong. When we look at what is being done in Hong Kong, it can either be a place where business is done in the sense of entering into contracts, producing something, or simply management, administration, board of directors, top management, making decisions on what happens in another country. Neither is determinative. And so then we have to look at the factors in a very open-ended way, and then look at them in connection to the company's other activities. And so this is analysis which is difficult and open-ended. The declaration to authorities or declaration to the public is going to be strong. However, when we see a certain level of contracting, a certain level of administrative activity, then it will be difficult to know in advance whether that constitutes a place of business in Hong Kong. And in Yunkai, at 3 levels of analysis, first instance, appeal, and final appeal, it was found that the Yunkai Holdings, which, as I said, only holds shares in Long Yao, which itself is a holding company of operative companies, that Yunkai Holdings did not have a place of business in Hong Kong.